Good morning. Welcome to the First District Court of Appeals. Good morning, Mr. Grauman, Ms. Adams. Our first case to be argued today is State versus Montoya. Mr. Grauman, how much time would you like for rebuttal?
I could reserve 3 minutes, Your Honor.
Absolutely. You may proceed when you're ready.
Ms. Adams, members of the court, may it please the court. My name is Nick Grauman. I'm here on behalf of Brandon Montoya. And what this case boils down to, the issue at hand was the state's motion to amend the criminal complaint. So initially, my client was charged, among other things, with criminal child enticement. And the charging document, the complaint, only listed revised code section 2905.05. It did not list a subsection, but in the basically to-wit portion of the complaints, it tracked the subsection, or it tracked the language of subsection A of that statute. So basically, the charging document listed that my client was charged with 2905.05, but in the to-wit portion of it, used the statutory language as if he was charged with subsection A of that violation.
And when we get down further in the complaint, it does include some factual details that at least arguably are consistent with subsection B.
That's yes, arguably they are similar to subsection B, but again, there's what's listed as the charge and what's listed as the statutory language for charging it is either 2905.05 or subsection A. There's no mention of subsection B. And to your point, Your Honor, at that point, if you're going to rely on the factual language to try to decipher and discern what subsection the state is actually charging, I don't think that's proper. Additionally, too, again,
and I think that's a question I've looked at somewhat closely in light of the briefing here, and I had trouble finding cases that would really kind of focus on that issue. So, are you aware of authority that would say we shouldn't consider the factual allegations that are in the complaint? We should only consider the statutory language that's used in the complaint.
I'm not aware of any case law to that effect, Your
Honor. Counsel, would you argue that the complaint did not inform your client or did not give him notice of what he was being charged with? I mean, the language with the factual information was pretty clear. Would you say that didn't give him notice that he was being charged with an offense with sexual motivation?
Yes, I would argue that. Certainly the factual language indicates there is some type of sexual motivation or some type of sexual issue. But again, nothing in the statutory language of it or where it lists the actual violation of the statute would seem to indicate that he's charged with subsection B. I mean, arguably, you could say he was also charged with subsection C as well, based on the factual language. So again, you're left guessing as to what subsection the state wants to proceed on. And as this court's aware, this is important because subsection A has been declared unconstitutional by the Ohio Supreme Court. So, and to that effect, I think what can't be lost on this is the fact if the amendment changes the nature or the name or identity of the charge, then I don't need to show that it was prejudicial to my client. Prejudice is assumed, and that's from the 12th District in Middletown versus Blevins. We don't need to show prejudice when it changes the name or identity. And looking at the Wright case, WRIGHT out of the 6th District, they found that an amendment from subsection A to subsection C changes the identity of the offense. Clearly, in this case, adding in the language, changing it from the statutory language of subsection A, which it tracks, adding in with a sexual motivation, which would be a violation of B, like the right case, changes the identity or the identity of the charge. So the amendment was improper. And this is critical because the proper move for the state would have been to dismiss and refile, but the state was handcuffed because they would have been out of time to be able to do that. So that's what makes this issue so important in this case, is the bigger ramifications from being allowed to amend it versus having to dismiss and refile. The second district as well in Whitehead, in language not necessarily pertinent to the ultimate finding, noted that the B and C subsections of the criminal child enticement statute were different from the A subsection because those subsections add additional elements. So again, this addition of additional elements changes the identity of the charge my client and the charging document was facing. So in light of that, I think the state's amendments or the court allowing the state to amend the charge was improper and in violation of Criminal Rule 7D. It changes the identity of the offense. Wright and Whitehead support this, and the fact that the offense level does not change, the fact that there was basically surplusage of factual allegations in the charging document, the fact that the penalties are the same, that's irrelevant to a Criminal Rule 7D analysis. It's simply whether it changes the identity of the charge. And I think it's a stretch to argue that my client was put on notice through that document. He was charged with subsection B. There's nothing even referencing subsection B, and if you're left for a defendant to guess just based on the factual allegations contained in the charge and not the fact that he's not put on notice with something actually listing the subsection he should have been charged with, leaving defendants to speculate and guess and decipher is improper. And
I think the state agrees with you on that last point, because that seemed to be what prompted their amendment in the first place.
Right. And you know, I think there's also the concern on the state's end, at least at the trial level, that if they didn't amend, then there's the argument, again, based on the statutory language, that it was a violation of subsection A, and that was improper and couldn't proceed based on the Romage or case out of the Supreme Court where it's been found unconstitutional. So in light of that, we'd ask the court to reverse the trial court's decision, not permit the amendments, and make the state proceed properly. And again, back to the reason why that's so important in this case is the fact that the state would have had to have dismissed and refiled, which it was out of time to do. So we'd ask the court to grant our request and overturn the trial court's decision. Thank you.
Thank you. Ms. Adams?
Morning, Your Honors, Mr. Gannon. I believe that as I've set forth in our brief, the amendment here, and I'd like to point out it's in complete compliance with Criminal Rule 7, in that it does not change the name or identity of the offense. And I think that the guidance that we've been offered from the Ohio Supreme Court is it's somewhat determinative here, whether or not it changes the name or identity of the offense when the penalty or the degree of the offense is not changed by the amendment. So in this scenario,
well, then that kind of begs the question of why did you try to amend it in the first place?
Well, I believe that and this is what distinguishes this particular case from the authorities cited by the defendant, is that those cases you had a specific subsection listed in the complaint, and then the amendment was requested to be changed to a different subsection. Here, there was no subsection at all. Although the part of the complaint tracked the language of A, well, all of the subsections fall under that. They contain that A language, and then the B and C just add additional. And I think that it was sufficient that it's hard to fathom that he was misled in any way by the specificity as to what behavior he was being charged with.
Well, let me ask you this. If you read the factual aspect of the complaint, how is the defendant supposed to know that the state is proceeding under B rather than C? Because it would seem like the violation could equally be under C.
Well, and again, I think that's why to clear anything up at the moment that they're going to trial is when the state asked for that amendment. So I think that if we look at, and again, he's not being misled here. The language is, the description of his behavior is very clear. And quite honestly, I think that gives him better notice than just the generic, it was sexual, it was committed with a sexual motivation. His specific behavior was set forth. There's no question what behavior.
Well, I guess part of the issue too is like, does this, if we agreed with you, would this allow the state to not list the subsection at all? And in a statute that maybe has 10 subsections, kind of wait and see how the evidence was shaking out and then say, well, I'm opting under C or I'm opting under G once you kind of did some more investigation. I mean, is that possible?
No, I don't believe so. I don't think, I mean, and that would, I guess imply that there was something nefarious going on here. Again, I would agree if there was nothing listed as to what the behavior was. I think that's pertinent here, is in the, especially when you have a statute like that has all of the subsections have very similar the beginning portion, and then to specify the subsection I don't think adds anything. And again, this is what distinguishes this case from the other cases that have dealt specifically with the criminal child enticement issue, where we didn't have a subsection at all. And when it gets to the moment when, oh, okay, and I don't know obviously what happened at the trial level, if it was just, oh, it wasn't listed, but clearly I think the language is what's more important as far as indicating that the defendant was in no way misled here.
So if the complaint were exactly as it was, except it did not list the factual allegation here, would you agree with the defense perspective that the amendment would be improper?
Correct. If we didn't have that factual aspect, I definitely would agree that it would not have been an appropriate amendment. But in this scenario, the state believes that this was completely in compliance with Criminal Rule 7.
Okay.
Thank you. I don't have anything to add unless there's any questions.
I want to continue on with what Judge Bergeron was asking a minute ago, as far as if the state lists something without a subsection and then later adds it, doesn't this kind of open up the door though to exactly what he was asking, that the state can have a statute without a subsection? I mean, doesn't that open, if we were to rule in your favor, wouldn't that open the door to that?
I don't believe so. Again, and oftentimes, we look specifically at this statute when we have the subsections. I'm sorry, my light went off. Okay, can't even see my paper. That you would have, potentially a change in the penalty or the degree, and I think that's a significant factor that the Supreme Court puts forth in doing this analysis. So oftentimes when you have those multiple subsections that are listed in a statute, the reason that's put forth there is that it's changing, degree or penalty. And in this scenario, we don't have that. So I think that is important. I can't think of an example off the top of my head that demonstrates that. But I think under this scenario that's before the court, that this was an appropriate use of an amendment for the complaint.
Okay, and then another question. So the complaint exactly tracks A, which, as you pointed out, is part of B. But the fact that it doesn't have that additional language in there, does that suggest that that was purposely left out?
Obviously, I can't speak to that as far as, why that occurred. I think that, again, looking just at this case, I think the specificity, it's actually more beneficial to the defendant here, that specific behavior was set forth instead of the generic sexual motivation. I mean, he's put on even more notice what offense he's looking at and what behavior he's being charged with. And so I think, again, looking at this particular case, it's hard to do hypotheticals in a scenario like this when all of those particular elements are hard to set forth. And
it's pretty rare to see a complaint when that doesn't specify all of the elements, and not in the factual, not in the to wit section, but before that, I think it's pretty rare to see that from all of them that I've seen before. You've maybe seen more municipal or misdemeanor complaints than I have. Again, I just, in looking at this case, I think that was an appropriate use of the amendment. And I don't know why that occurred, but I think they did what was provided in the rule under these scenarios to fix that matter.
Okay, thank you, Ms. Adams. Mr. Grumman, you have rebuttal.
Just briefly, to the concerns that were raised, I agree. At this point, if you were to side with the state, then why would the state ever be required to specify the subsection? So long as they lay out a sufficient factual basis in the to wit portion. And my mind goes to now this charge, again, I believe only has 3 subsections, but something like an OVI violation or even the disorderly conduct statute that has numerous subsections. So long as the state, if the court were to side with the state in this instance, so long as the state laid out some factual allegations to support any number of the OVI subsections in that statute, it wouldn't be required to list it as an A1A or I think the drug subsection is under J or K. So that would remove that requirement. And it's not a question of being misled or the defendant being misled so much as it is the state choosing what route or should be required to choose what route and elect what route and charge that it is going to prosecute my client under or defendants under so that they are properly notified and can properly defend. Otherwise, it's almost a shotgun approach if the state's not required to specify a subsection that they can just list out factual allegations, throw everything up against the wall and hope it ultimately ends up fitting and convicting under one of the subsections. So I think that's certainly a very real danger if the court sides with the state to no longer place them under the requirement to specify a subsection to give defendants that clear route as to what they are defending themselves against. So in light of that, we'd submit that, again, the amendment was improper and ask the court to continue to require the state to specify the subsection. Otherwise, that's certainly going to create a slippery slope, and the state can certainly abuse that. So that's the extent of the rebuttal that I have. If the court has no further questions.
Mr. Graham, I do have a question for you.
Yes, sir.
I'm looking at the complaint, and I know these forms are provided by the clerk of courts or the municipal court. And when the officer arrives, they take the proper form, fill out the particulars like date of birth, date of occurrence, etc. is that still the case? These are essentially form complaints that are filled out by the officers.
Your Honor, I believe so, but I can't speak from experience to that. Certainly, the officer does have some input because he is writing in the factual allegations, but I cannot say who's responsible for generating the statutory language in those forms and what they're required to fill out.
Okay, thank you.
Thank you.
Thank you both for your arguments this morning. We appreciate them. The case will be submitted and we'll issue a timely written decision. Hope you both have a great day.
Thank you.
Good morning to you both. Welcome to the First District Court of Appeals. Our next argument is State versus Harris. Morning, Mr. Kutcher, Mr. Conser. Mr. Kutcher, how much rebuttal time would you like today?
3 minutes, please.
Excellent. You may begin when you're ready.
Thank you, Your Honor. May it please the court, opposing counsel, Mr. Conitzer. This morning, we bring to the attention the case of Samuel Harris. This is a criminal case from 2016 where he had 3 charges, and we bring one of those convictions to the attention of the court today. From a high level, looking at the case, Mr. Harris was incompetent at the time the case came into court. He was apparently restored to competency, where he entered a plea in relevant part to this appeal to sexual imposition, a misdemeanor of the 3rd degree. At that time, he'd already served his maximum 60 days, so he was sentenced to those 60 days, and his case wrapped up. Now, he had 2 other charges. One of them I know was a theft, and he also pled to a theft. He was placed on probation for the remaining amount of time for that theft. And a few months later, he came back in for a probation violation on that theft, where counsel at the time apparently moved the court for another competency evaluation, and he was incompetent. And eventually, that probation violation was dismissed for competency. And I guess what also happened was Mr. Harris filed a motion to withdraw his plea pretty much immediately after his conviction for sexual imposition. He filed that pro se. He ended up with appointed counsel for an appeal in 2017. And so one of the issues we bring to the attention of the court is ineffective assistance of counsel. His original trial counsel in January of 2017. And frankly, hindsight brought this to our attention. And the hindsight is we had a defendant incompetent, allegedly restored for just enough time to enter a plea, and then incompetent after that. And one thing we will acknowledge that the city pointed out in its brief is that different counsel represented Mr. Harris for his first appeal. We will also acknowledge that different counsel had all the evidence in the record relevant to make a determination as to whether or not they wanted to bring ineffective assistance of counsel to the court's attention that first time. And if res judicata applies, we won't acknowledge that it applies, but if the court finds that under those circumstances res judicata applies, then certainly our ineffective assistance of counsel claim this time fails.
Well, typically for ineffective assistance to work in kind of a post-conviction setting, you need to show new evidence that was not available in the trial record. So what is the most kind of pertinent new evidence that you have in this case?
The most relevant evidence, Your Honor, is an allegation by his new trial counsel, who in December of last year filed to withdraw Mr. Harris's plea. In his motion and in oral argument, he alleges that he was provided files by the public defender's office. And those files contained body cam footage, contained a written statement, and I think just generally, without specificity, talks about files. What we don't know, since a full evidentiary hearing was not permitted by the judge in December, it's not clear to me whether all that footage was available, that footage and files were available to trial counsel in 2016 and January of 2017. So I think when trial counsel in December of last year filed to withdraw their plea, I think it would have been great if they provided some sort of affidavit or some sort of very specific explanation of what might be newly discovered.
Well, yeah, and I mean, I think that's the predicament that we're in. Like, without that kind of specific evidence, like, what are we supposed to do other than just kind of engage in speculation on what that evidence might show?
Well, I think that leads to the other issue we bring before the court, which is, at this time, Mr. Harris is asserting actual innocence. And because he asserts actual innocence, we direct the court to its own case, State versus West from 2015, where a claim of actual innocence with the motion to withdraw a guilty plea requires a full evidentiary hearing. So to answer your question, what I think the court can do is remand this case back to Judge Peck, who is the presiding judge for this case now, with a direction to have a full evidentiary hearing to determine whether these files, body cam footage, the written statement were available to trial counsel in 2016. So back to the ineffective assistance, if we can get past the res judicata hurdle, and if we can talk about an objective reasonableness standard of the counsel that is guaranteed to indigent defendants via the Sixth Amendment, then we can talk about what we know about the case, which is, looking at the docket, it appears that the original trial counsel in 2016, 2017 never filed a request for discovery. We also see that counsel was appointed, I think, on December 20th of 2016, and the case was set for trial after a single pretrial on January 12 of 2017. Taking into account the holiday season there, I counted that there were 12 business days from the time of appointment to the time of taking this sexual imposition case to trial. Now, on one hand, it's a misdemeanor 3. It's not the most serious, highest level charge in the world, but it comes with a requirement, if found guilty, to report to the sex offender database for 15 years. Now, I will also acknowledge, I know that the courts have said that the duty to report is non-punitive. It's simply an administrative procedure. But I think the reality here is only 12 business days and no request for discovery. If we look at an objective reasonableness standard of counsel guaranteed, it falls short. So with that, Your Honor, I'll respectfully submit.
Thank you, Mr. Kutcher. Mr. Conitzer.
Morning. May it please the court.
Morning.
Mr. Kutcher kind of touched on, I think, where I'm going to start today. Our main position is that both of these new assignments of error should be barred by res judicata. As we noted in our brief, this case was after the first motion to withdraw the guilty plea, I believe, brought up under, it was C170053. That was, again, by a different attorney than the trial counsel, as Mr. Kutcher already acknowledged. On that appeal, they brought up the 3 assignments of error were a denial of his right to allocution. It was the denial of the motion to withdraw his guilty plea. And there was an allegation that the trial court improperly noted the competency on the judge's sheet. All of those assignments of error were overruled. The judgment of the trial court was affirmed. And on that, under State v. Ragland, the trial court actually did not have jurisdiction to hear the second motion to withdraw the guilty plea, specifically because there was no new evidence that was added to it. It kind of went back to the trial counsel's official or original point on the plea date. As to the ineffective, that kind of goes towards the failure to raise that at the first appeal as well. It was not one of the 3 assignments of error. Because of that, that would have been waived and is unable to be brought on this second appeal. Again, because there's nothing that was outside of the record that's being alleged from the initial appeal. So that's kind of as far as we go as res judicata. We just believe that these should be barred. If you do decline to accept those, we do believe that the court was still correct in denying this motion to withdraw the guilty plea the second time. Basically, on the merits, criminal rule 32.1 doesn't allow for the withdrawal of a guilty plea after sentencing unless there's a manifest injustice. Mr. Kutcher is alleging that there is a claim of actual innocence here, that if that were the case, would maybe be a manifest injustice this court could go look at. However, based on what they are claiming is evidence for the actual innocence, still would support the state's case and still support a conviction under the law of Ohio. Mr. Harris admitted that he, I believe, rested his head on the victim's breast in this case, in erogenous zone. There's no admission of sexual gratification, but under the case law in Ohio, that's not necessary. The court can look at the touching of an erogenous zone and determine that because that area was touched, there is they can infer that there is for sexual gratification. They also mention that on the body camera, Mr. Harris was allowed to leave the scene at the time. And frankly, I don't believe that goes to any sort of actual innocence claim. I mean, the police do what they do. That happens frequently. They let someone go, later on decide to bring charges and bring them back in. As far as the, he does state State v. West for the need to hold an evidentiary hearing. But as far as State v. West goes, that case, when it was a father accused or convicted of raping his son, and on the motion to withdraw the guilty plea, there was an affidavit from the victim in that case stating that this didn't happen. So that was the new evidence that was presented along with the motion. In this case, we have a few allegations.
So in other words, if it is a claim of actual innocence coupled with new evidence that is probative of innocence, then you would agree there would need to be a hearing.
I would. And I think that's kind of what criminal rule 32.1 gets at. To correct that manifest injustice, you would need that hearing. Here, we don't have that evidence. There's notes in the second motion to withdraw the guilty plea that I got this file, there's body camera in it, there's all this other things. Yeah, there was no discovery request, but that was on the file from the public defender. I mean, we presume that the trial counsel had that in his possession. There's speculation that he may not have looked at it. There were 12 business days. He still may have looked at it over the holidays. There's just kind of a lot of speculation going on as to what evidence may or may not be there, and that's not the requirement. The requirement is there needs to be new evidence that was not available at the time to bring this, to have the evidentiary hearing for the trial court to look at. I mean, at this point, they may just want to have the trial as an evidentiary hearing on the motion to withdraw the guilty plea because there wasn't one earlier. And that same kind of thing goes towards the ineffective assistance of counsel. Under Strickland v. Washington, there are the 2 prongs that I'm sure everyone's aware of. There's the performance has to be deficient and the defendant has to be prejudiced because of that deficiency. At the original plea date, on the transcript, the defense counsel assured the court several times that he believed the defendant to be competent. He had already served the maximum sentence, 60 days. He was given the 60 days credit, 60 days. And as Mr. Kutcher mentioned, the sexual registration requirement of this is not punitive. It's an administrative, it's a function of the law as these kinds of crimes go through. So even if you were to look at beyond res judicata and look at this case on the merits, I mean, there was nothing new for the trial court to look at when it came time to have this motion. And as far as the ineffective assistance, there's just been no showing of prejudice to the defendant.
Okay, so thank you for your argument. Mr. Kutcher, any rebuttal?
Yes, please, Your Honor. So we'll acknowledge there is some speculation going on here. But the speculation can easily be resolved by an evidentiary hearing in front of Judge Peck so that the new trial counsel can present with specificity the files, the body cam, and the written statement. With respect to the written statement, we know from new trial counsel from that proceeding, we know that the police invited Mr. Harris down 2 days later to write a statement about what happened. But I think what's not fully uncovered here is that Mr. Harris has mental health issues. He has mental health issues today, as we learned from the most recent proceedings, and we know about the evaluations from 2016. So when the police invited this person down and told him why he was there and why they wanted him to write a statement, we don't know what sort of mental state that person was in at that time. And most importantly, we don't know if trial counsel in 2016 and 2017 knew about that written statement, whether he evaluated it at all. And I'll leave with an objective reasonableness standard, that sort of review of trial counsel's performance and the rush to judgment in 2016 and 2017, I think requires a finding of ineffective assistance and allowing Mr. Harris to withdraw his plea at this time. If not, I think the court needs to remand to the trial court with instructions to have a full evidentiary hearing so that the affidavits, the new evidence that probably should have been submitted originally with the motion in late 2020 to withdraw his guilty plea, those items probably should have been provided to the court with specificity, but an evidentiary hearing can cure that now, and we can find out once and for all if any evidence is newly discovered.
Mr. Kuchar, let me ask you a question. Earlier, you spoke of the short time between the entry finding your client competent and the guilty plea. Looks like the court found him competent on the 20th of December, 2016. And then a plea was entered, as you said, several days later. Looks like January. So my question is I'm assuming the court had a report from either the court clinic or the place where your client was housed, indicating to the court that he was in fact competent at the time. Am I correct in that?
You are correct in that, Your Honor, and further that defense counsel and the city stipulated to that finding.
All right.
Now, what I'll bring to the court's attention there is, as far as deficient counsel performance goes, with Mr. Harris being incompetent before, and then honestly, with the hindsight, how we see he was incompetent after, it may have been most appropriate to ask for a second evaluation at that time.
Okay, thank you both for your arguments this morning. We appreciate them, appreciate your time this morning. The case will be submitted and we will issue a timely written decision.
Thank you, Your Honor.
Hope you both have a great day.
Thank you, Your Honor.
Thanks.
Good morning.
Good morning to you both. Our last
Morning.
case to be argued today is Maramon versus Maramon. Ms. Daddario, do you, how much time would you like to reserve for rebuttal?
I'm actually
Your Honor, if I,
Oh, I'm sorry, I had it backwards. I apologize. Mr. Hoberg, how much time would you like for rebuttal?
Your Honor, if I could reserve 5 minutes for rebuttal, I'd appreciate that.
Sure. All right, whenever you're ready.
Thank you, Your Honors. May it please the court. Your Honor, we are here today to address two issues on appeal that was initially raised by father in a post-decree request to amend a shared parenting plan. The post-decree litigation essentially was created by father by filing a motion to reallocate parental rights and responsibilities based on an event that occurred from mother going on vacation to Florida in the middle of the school year, in the middle of a hurricane, during an evacuation order. Shortly thereafter, mother filed for her own motion to change the school district of the children in this case, and to have mother be designated the residential parent for school enrollment purposes. As a result of that motion, father in this matter requested an in-camera review to be held for the eldest child in this case, because it was his understanding that the eldest child did not necessarily want that to occur, and to allow that eldest child to have his position be taken into account as it relates to it. Now, that in-camera review was neither granted nor denied by the trial court in this instance. Instead, shortly thereafter, a parenting investigation was ordered, and that parenting investigation was held by, I believe, Laura Bradford, as it indicates in the record. Now, in that situation, in that parenting investigation, the conclusions of that investigation actually were that father should remain the residential parent for school enrollment purposes, and mother's parenting time should be curtailed or amended because of the issues with a change in her occupation. She had recently become an EMT, and as a result of that, as Dr. Bradford concluded, that that her schedule doesn't necessarily, that change in her profession actually creates some problems when it comes to reviewing divorce issues, when it comes, or determining parenting time when it comes to divorces. Now, that really goes into our second assignment of error. Our first assignment of error, though, is that we believe that the trial court erred by failing to conduct an in-camera review when requested by father's counsel in this case, or specifically, regardless of when it should have occurred, either before the actual trial setting or shortly thereafter the trial, depending on whether the facts and circumstances warranted. Regardless, father timely filed for one.
Counsel,
yes.
Can you distinguish your case from the Fritz v. Fritz case out of this court?
Sure. Oh, go ahead, Your Honor. I'll allow you to. I'll allow you to.
If you know the case, I'll let you go ahead.
I'll actually, if you could proceed with refreshing it, that actually would be helpful.
Sure. So that court found that the modification of a residential parent for school purposes is governed by 310904E2B.
Yes. So if you look, and thank you, Your Honor, if you look at 3109E2B, and if you look at, I believe, King, which is a similar case to Fritz, as we cited in our reply brief, that analysis, if you go through the journey, actually still ends up with 3904B when it comes to analyzing it. Specifically, when you look at E2B, in the King's case, it also still determined that when you were reviewing the best interest factors for 310904E2B, you still need to look at the factors at 310904F1. And if you go through 3904F1B, you end up with the in-camera factor for determining a child's best interest. And in 3904F1B, it points to paragraph B of the statute, which in that situation, 310904B actually outlines that
but the best interest criteria only says if the F1B, only if the court has interviewed the child in chamber. So that doesn't suggest that the court has to.
And I would say that if you review, in reviewing the statute, it also outlines language as it relates to taking in, uh, uh, it states that when making the allocation of parental rights and responsibilities for the care of the children under this section in an original proceeding or any proceeding for the modification of a prior order of the court making an allocation. It doesn't explicitly state that it is, as it relates to strictly reallocation of parental rights and responsibilities. And then in the subsequent sentence, it actually states that in determining the child's best interest for purposes of making this allocation of parental rights and responsibilities for the case of the child, and for purposes of resolving any issues relating to the making of that allocation. And in this situation, certainly when we're dealing with a shared parenting plan and the allocation of parental rights and responsibilities, one of the things that needs to be determined in making that plan is where the child is going to be going to school, who the parent is going to be for purposes of school enrollment purposes, and in addition to the parent, in addition to what the visitation order should be as it relates to this. Following the statute, going from 310904E2B to the F1 section back to 310904FB, you still end up with, essentially requiring that analysis. In addition to that, even without the review of that particular analysis, certainly, going towards the manifest way of the evidence standard and requesting the abuse of discretion, or determining that whether an abuse of discretion occurred, we believe that even with, if the court decides to hold this particular analysis, the failure to conduct it in this situation would still amount essentially to an error. This is a situation where, the child was certainly old enough to state what his wishes and preferences are. And this was about where the child is going to go to school.
And I think that does make some sense, but I guess since everyone agreed that they didn't want to go to the high school in father's district and then mother moves to a different district, that presents a difficult situation for anybody, particularly when you have, by all accounts, two very committed parents. But that also is an issue that just seems uniquely suited for the exercise of the trial court's discretion based on the record at hand. So I guess I'm just curious as to your best argument as to why we should overturn that exercise of discretion.
I think with that exercise of discretion, if you actually look, if you look at the evidence and the court's decision on that, it was based on essentially a speculation that mother would have more parenting time with the children during that school week, just based on mother's bare assertions to the record. However, in the evidence that was presented with Dr. Bradford's testimony and her report, she actually contradicted that by saying that mother's schedule is actually one that creates difficulties when it comes to such a visitation schedule. This is a situation where, in addition to the parents, we have committed paternal grandparents in this situation. And I believe the trial court was trying to avoid, made the assumption that the parental grandparents' time was being used exclusively by father, when the record actually indicates that both father and mother utilize paternal grandparents in this situation for visitation or for supervision. And then on top of that, as a result to mother's schedule and changing her schedule with her work obligations, we're going to end up with a situation where, as she indicated in the record, we wouldn't necessarily have these paternal grandparents whom the children are clearly bonded with and have this relationship with, but we're going to, mother indicated that she's going to be utilizing neighbors and a step parent, and neither of those parties really are perhaps better suited to exercise that sort of relationship than the paternal grandparents, which the children have had that relationship with, stemming back even prior to this litigation. So, Your Honors, because of this, we're requesting the court to reverse and remand this matter to hold the in camera, or in the alternative, another directive if it held that the court did abuse its discretion when it comes to determining manifest weight of the evidence.
Mr. Hober, let me,
Yep.
before you end here, let me ask you a question. I agree that this code section 3109.04 is not a picture of clarity, but haven't the courts interpreted the necessity or the mandatory nature of the in-camera interview with the court when it involved the original decree or an order? And haven't the courts held that when there's a modification of the shared parenting plan itself, which is apparently appended to that decree or order, that there is no necessity for the in-camera interview by the court?
I would agree with the former, Your Honor, as opposed to the latter. I don't believe when it comes to an in-camera, they really hang their hats, and in terms of that is to determine whether or not there's a requirement for a finding of a change in circumstance, and having to go through the rigmarole of determining a change of circumstance when it comes to amending an order, not necessarily permitting a child's voice to be heard by the court when it comes to a post-decree matter.
Okay.
Okay, thank you, Mr. Hoberg. Mr. Dario.
Thank you, Your Honors. May it please the court. The trial court's decision ultimately left us in a situation where we have 3 kids, all of different ages, all of different school grades. Her decision basically decided that these 3 kids are going to settle in a new school, which they have already done for this school year, that they're going to know which school they're attending for elementary, middle, and high school. They're going to have friends that are established. They're going to be in an A-rated district. They're going to know what they're going to be doing all the way through high school graduation. They're not going to have this lingering question of where they're going to go to school based on each child's unique abilities. Father's position throughout trial, despite this having been pended for over a year, was we will figure it out. I know I don't want Coleraine. I know I don't want Lakota, but everything else, we'll figure it out. His thought process means that we could end up with 3 kids in 3 different school systems all across the city. Father did not provide any testimony that any of these kids could test into schools like Walnut, which are free, or that they could afford a private school like Moeller. There was absolutely nothing done. What he relies on is.
But I guess why, given the age, particularly of the eldest child, why was an in-camera review not conducted here?
Why was the in-camera not conducted?
Yes.
I can't speak as to why, but I can say that it is our position, of course, that it was not mandatory for the reasons that you've already explained. However, I believe it was not an abuse of the court's discretion to not hold it. There was a custody investigation done. She interviewed the children separately, individually, although it was done over Skype or Zoom. There was nothing indicated that they believed there was outside influences, like in other cases, that would render those interviews, misleading or inaccurate. So Carter is.
But that investigator concluded that the kids should remain with father, right?
Correct. And on cross-examination, there was really, from our perspective, very, very little to back that up. There was no teachers. Anyone indicated the kids were excessively tired. Father said when the kids got to his house in the morning, they're tired, but there wasn't really anything to say that they're struggling, their grades are bad because of this. Carter told the custody investigator his parents will have to figure it out. That's what he said. That's what he understood. The custody investigator she testified as to what each child relayed to her in regards to school. There was ample room for cross-examination. There was no hindering of her testimony, like in other cases. The children's wishes were explicitly put forth in trial through the custody investigator. There's absolutely no reason that an in-camera interview should have been conducted. And secondly, Father is very clear that we should wait and see and figure it out when the time comes closer to him starting high school. So the child, if he were to tell the judge in the in-camera interview, here's where I may want to go, it really doesn't matter. Father was clear, we'll have him tested. We're going to have him tested. So what would an in-camera interview do if he's going to rely on these test results as to where Carter is going to attend high school?
Well, so first of all, I would suggest not using the child's name.
Oh, I apologize.
But if the, but wouldn't the child be able to say something to the effect of, I really don't want to go to this new district. I have all these friends in this district. I have, my grandparents who look after me. I mean, something along those lines, even though that would not be necessarily probative of exactly where he would go to school. But I mean, that kind of information could have come out.
I agree. One thing that is really important, though, is he does have friends in his current school, I'm sure. However, father doesn't want him to attend the school that he's supposed to attend, Coleraine High School. He's going to go somewhere else. He's going to have to make new friends. These people aren't going to go to the same school because they don't know what that school is. And the trial court's decision leaves the parties with roughly equal time. When it's mom's parenting time, she is not working. She will be with them 100% of the time. When she indicated about neighbors and step parents, that question was meant to say, if you needed help, what's available. However, the goal is, the premise, what's happening now is she's spending all of her time with her kids. Unlike father, who wasn't even working, and everyone still indicated they don't spend enough time with him. They're mostly with their grandparents. He's always in the garage. That's father's choice. He's choosing to let his parents do all of the work. There was testimony that grandmother did homework, breakfast, getting to school, bedtime, all of these things was in grandmother's hands, and that was father's choice. So grandparents are still going to be involved half the time, essentially, if that's what father decides. Ultimately, father's trying to significantly reduce mother's time. Mother's goal is to maximize the amount of time each of these children have with their parents. If we could, I want to go back to what father started with, the argument. Mother went on vacation to Florida. Mother took the children to a funeral. It was her sister's funeral, and it was an extremely tragic event. And to call it a vacation is unfathomable. Unfortunately, alongside this funeral was also a hurricane. A lot of adjustments had to be made. Mother was not going to miss or allow her kids to miss her sister, the children's aunt's funeral. Because of the hurricane, there was rerouting that had to be done. They ended up in Orlando because of a family member's connections. They were near Disney. They did not go to Disney World whatsoever. They were at a hotel near it. Father has been made aware of that many times, yet he continues to call this.
Counsel, didn't father withdraw his motion to terminate shared parenting?
He did.
Okay. So is that trip still relevant?
He is still claiming it's relevant because he's still trying to reduce his mom's parenting time. He was arguing that mom shouldn't have parenting time, I guess, during the week in part because of this one incident. So he did orally withdraw the custody portion. However, he was still moving forward regarding modifying. And to get to that point, it's our position that modifying the term of a shared parenting plan does not require a change in circumstances. It does not trigger the requirement of 310904 F1 to have an in-camera. The in-camera is discretionary. F1 refers to changing a decree. The decree of shared parenting states only that both parents are residential parents and legal custodians. It doesn't say anything else. A term of the shared parenting plan, as indicated through the case law, is where the kids will go to school, things that are going to change over time. So by modifying the term of a shared parenting plan, there's absolutely no requirement for a change in circumstances. There was sufficient testimony that would warrant the court to find that it's in the best interest that mom be the residential parent for school purposes, and that the parents continue to follow the schedule that they came up with on their own. I mean, I think we all agree that's the best thing we can do in these situations, is to let parents do this on their own and see what works. And they came up with this schedule on their own because mom began a new career path specifically so that she could be with her kids more, so she could spend time with them and be involved and be available. And because of that job change, they came up with a schedule that it requires some flexibility. It requires, it's not always the same, but we always know mom works every third day. And we know that both parents are going to have equal amounts of time available to them. And for father to say they should only see mom on weekends and some weeknight visits, it's absolutely not in their best interest. We have a woman who was a stay-at-home mother who was used to being there for them, who was used to doing the school parties, who was used to volunteering. And father blatantly is trying to really cut her out. He really just wants her to be every other weekend parent, even though when it's his time, he's not exercising it. He's in the garage, he's doing other things. Another issue is father was unemployed. We have no idea what his job schedule is going to be. He was desperate. I know he really, really wants a 9-to-5. Doesn't mean he's going to have it. He's never had it. We don't know what that's going to look like. Mom, in father's brief, he's indicating that mom's schedule changed and the court didn't consider that. That's not true whatsoever. Mother's schedule, we know what it is. It's not going to change. It wasn't a temporary schedule. What was temporary was when mom was in school, she needed a lot of help and dad was there for that. And she was very appreciative. But now we know what the schedule is. There are no questions. Laura Bradford's comment that she obtained a career that has a difficult schedule for divorced parents isn't indicative of anything. She chose a career to be with her kids more. That should be rewarded. The response shouldn't be, let's take her time away, because it has a rotating schedule that makes things hard. What it does is maximize time with parents, which is the most important thing. I wanted to touch on a certain point. I apologize. I apologize. I lost my page. I apologize. If we want to, I'm sorry. If we want to look at some of the case law, I feel very strongly that the case law is in support of the fact that the change of circumstance was not required. Modifying a residential parent for school purposes is just a term of a plan. As you indicated, Fritsch is a very clear holding. Father's reply brief was arguing that you guys should be limiting your holding only for parents who they're not the ones asking for the change. And obviously the holding this court made was not about the facts of the case. It was about the language. And while yes, the language of the statute isn't always ideal, I believe this part is very clear. They did not have to find a change in circumstance, just like they did not have to conduct the in-child interview, the in-camera interview. And, we were fortunate. We have the Supreme Court case from just last year, which also confirmed again that the change of circumstance is not required to terminate a shared parenting plan. A lot of this is a result of father's decision. He decided for our knowledge, the day of trial, that he wasn't going to pursue terminating the shared parenting plan. It wasn't until the the opening statement that we learned that he wasn't proceeding with full custody. We had no idea. And because of that decision he made, that really changed the legal analysis that took place in this case. But ultimately, we think the judge was absolutely spot on in what she found regarding the parents had a major disagreement about school. Father has no clear idea what he wants for them. He wants everyone to wait and see. He wants everyone to have a say in the matter. For these kids instead to be in their new school, which they are again as of this year, and to know they're going to be there throughout their high school careers is what's in their best interest. They already have friends in the neighborhood from their church in Lakota. They know people, and they're going to know these people for the entirety of their school career. They're going to have a situation where they see both of their parents so much more than under father's suggestion. It's absolutely in their best interest. It's a better school. It's an A-rated district. It's a great school, each of them, the elementary, the middle, and the high school. Dad acknowledges Coleraine is not. And the shared parenting plan explicitly stated the parents agree the kids will go to Montfort through the 5th grade. They said that because they knew, assumably, that they didn't want Coleraine for their children's future. And frankly, with one child, being on an IEP, we have the first child who father thinks can test into schools, get scholarships, etc. Perhaps. And fortunately, Walnut is free. So that's good. But we have no idea whether scholarships will be available. The younger two, however, we don't have, mother testified, she doesn't think they're going to test into a school like Walnut. They're not at those abilities. So where they're going to go, I don't have any idea. And really, neither did father. He didn't point to any specific skills that would allow them to test into certain schools. It's a very, very large question mark. And it's really unfair for these kids that they're going to have to sit around the next elementary school and all through middle school, wondering where they're going to end up. And if the parents don't agree, we're going to be back in court in 1 year, as this middle child and the youngest child, of course, embark on high school. We know the parents don't agree, and the shared parenting plan requires agreement. So father's scenario really opens this up to litigation occurring 2 more times, 2 years of litigation for each kid, because he doesn't want Lakota. Can't really tell us why, he just doesn't want it. But he also doesn't want Colerain. It's absolutely not in the kids' best interest that they're going to have to go through that. Mom has what the kids need. She still wants father to be equally involved. Father, on the other hand, wants her to be as really, really not involved at all, which is extremely unfair considering the role she's played and the sacrifices she's made.
And counsel, you are at your time now.
Okay, thank you. So of course we are asking that the decision be upheld. Thank you.
Thank you. Mr. Homer, rebuttal.
Thank you, Your Honor. The trial court in this situation actually performed a change in circumstance analysis in terms of whether or not a change in circumstance occurred when it came to the motion that was outstanding. So I'm almost fully, I would almost be hesitant to even say that the court was attempting to apply E2B in this matter, because they made such a change in circumstance analysis. Well, some of the points that were raised by appellee just now are a couple of things I do want to touch on. The first is, as the court, as she indicated, this is, because of this, because of the court's order, it eliminates any question marks as opposed to where the children are going to high school. And in this situation, the kid, as a result, the kids won't necessarily have a say in it when the salient time occurs for that to occur, when the kids are just about to enroll in high school. Unfortunately, one of the things that seems to be an issue here in Hamilton County is where you went to high school. And by avoiding the ability to have the children at least have a say in it, at least have an articulation of it, and also for each child to perhaps have an issue based on what's in that child's particular best interest is something that perhaps is warranted. I believe that there's sufficient case law to say that it's that when it comes to issuing a shared parenting plan or a decision for school enrollment purposes, a court can't take into consideration the actual grades that are provided by the Department of Education. I'm happy to provide perhaps supplemental briefing if that's necessary. But you can't utilize school ratings, and who is to say that perhaps the high school for one child may not be the best interest for the subsequent child or the child after that. I think in either of these situations, we run into those particular we run into those particular issues in any situation involving post-decree. This is a situation that stemmed out of mother deciding to move to Monroe, doing so without filing, a notice of intent to relocation. And because of that, we are at this juncture where we are trying to determine where the residential parent of school enrollment purposes should be. Mother moved out of county, and because of that, now there's a geographic gap between where mother is, where father is, and where the paternal grandparents were. And, so that's why, the application of, determining whether there perhaps should be a change in circumstance prior to changing that is perhaps not necessarily an imprudent one, but when it comes to changing a residential parent for school enrollment purposes, if only for the fact to, make sure that parents don't necessarily game the system by trying to move to a superiorly rated school district and then try to pigeonhole some sort of best interest standard. I think if we go down that route, we do run into a slippery slope where that would potentially occur. This is a situation where mother moved out of county, and because of that, there's this greater difference in space, and it wasn't father's decision in order to do that. It wasn't his decision to allow mother to move to any particular place geographically, or mother to concentrate her job search in one particular area. This is a situation where when mother was proceeding with her request to change the residential parent for school enrollment purposes, father wants his son to have a say in the matter. And unfortunately, in this situation, that son was not given the voice that the Ohio Revised Code, permits it to happen. And because of that, it probably was not weighed in the same manner from person to person as you would have secondhand through a parenting investigator. And because of that, it was perhaps improperly weighed in making said decision. So because of that, we respectfully request the court to reverse and remand so that an in-camera may occur, and also in the alternative to allow more of a directive as it relates to if the court decided that there was an abuse of discretion in the manifest weight of the evidence.
Okay, thank you both for your arguments this morning. We really appreciate it. The case will be submitted and we'll issue a timely written decision. Hope you both have a great day.
Thank you very much.
Thank you, Your Honor.